And the second page, contract, they're claiming the gentleman owes over $14,000. I don't normally show you the amount. You don't know who this person is, but it's important that you know how much he was on the hook for when you see what happened at the end of the video. So the purpose of this video is to provide you with a ton of letters to send to work during garbage time, showing you a case study of a member that actually did everything I said, and it worked. After the summer, he contacted me to say, look what happened. And I'll show you at the end of the video exactly what happened, precipitated by the letter that he sent. The pen can be very poisonous in court. This video is going to be loaded with my special letters. You can use them. You can use them as skeletons for what you need, your facts and state law, for your use in Word. And you can either use them on the site in Word, or they will be embedded into Parker GPT, where you can just ask Parker GPT and it'll produce the letter for you. Hey, Brian Parker here with another exciting video. This one was brought to me by a member of our Killdebt.com website that used some of our letters against a lawsuit. That's possible. And I'm going to show you how today, as opposed to filing an answer or anything like that. I'm not suggesting that, but I'm going to show you how he did it. And it gave me an idea. So as I've counseled you in the past, you take their lawsuit and use their documents against them. You use their words against them. And today, in the subset of using their documents against them, I'm going to show you what to do with a loan agreement that benefits you. So hopefully this will work. So this video is going to be loaded with my special letters. You can use them. You can use them as skeletons for what you need, your facts and state law. But there is a lot of letters attached to this video, all attached to the video for your use in Word. And you can either use them on the site in Word, or they will be embedded into Parker GPT, where you can just ask Parker GPT and it'll produce the letter for you. So attached to this video today, here we go. I'll put it up. Shazam. A letter to PCA asking for proof. That's the debt buyer, that they own the debt. The ownership letter to Cross River Bank and Best Egg. Securitization letters to both Marlette Funding, Cross River Bank, and Marlette Servicing and Best Egg. A forward flow agreement letter to Marlette Servicing. A bill of sale letter to Marlette Servicing. We've got a lot of work to do today. An assignment letter to Marlette Servicing pursuant to the loan agreement. And in the letters you can see I've got numbers. Those are coordinated with the section of the agreement that mentions that entity. And I go, hey, show me proof of that division. So 16, for example, an assignment letter to Marlette Servicing, and then there's 16. That's the section of the loan agreement that talks about what duty Marlette Servicing has. And so you go, okay, duty to me, I'm part of the contract. Here, answer this question. So a follow-up letter. So the member that sent me his stuff, and I'll put up his follow-up letter, as I always counsel, sometimes they're gonna ignore you or send you a bunch of BS and say, here's a response. So he took their words and put it in a follow-up letter and said, I asked for this, you gave me this. Please follow up. And you're gonna be, at the end of this video, I'm gonna show you what happened when he sent that follow-up letter and these other letters. I'm also sending a letter to the signer of the bill of sale. That's the specific guy that signed the bill of sale. I'm sending him a letter. So are you in your bill of sale case, meaning whatever bill of sale you have attached to your case. A revocation of consent to contact me letter pursuant to the loan agreement. 15 and 18. At 15 and 18, the provisions of the contract, it says, well, I'll show you what it says. A governing law letter. We haven't heard about the governing law in a while. A member follow-up letter, as I said, detailing why they didn't do a good job in the first place. So you'll have my show notes, which I worked on all morning. Like, love, subscribe, and share this video and all my other wonderful videos. If you know a friend or family or someone that's in need of help, send this video. The lawsuit loan agreement in this case was attached to a lawsuit, obviously. Here's the first page and second page of the lawsuit. It's your basic debt via lawsuit. I may have used it in the past when the member first contacted me and says, hey, what do I do with this? Am I doing this? And I said, this is what I would do without telling him what to do. It's a Georgia case. I don't operate in Georgia. And he apparently did what I said, because after the summer, he contacted me to say, look what happened. And I'll show you at the end of the video exactly what happened, precipitated by the letter that he sent. So it's your basic first page, Cross River Bank, PCA. It could be any debt via Midland Credit, PRA, Crown Asset Management, all those guys. LVNV Funding, we love LVNV Funding. It could be any of those, but here they say PCA Acquisitions 5. Always check out 1 through 4, by the way. Anyway, because in the chain of title, they'll go 1 said this, 3 said this, 6 said this, 5 gets it. It happened. So if you see a number or a numerical number on the end of something, that means there's other entities. That is a whole chain of title you can take advantage of. And so they're saying they're an assignee of Cross River Bank. We shall see. I've purpled out or pinked out the contract because that's going to be what we're focusing on today. And the second page, contract. They're claiming the gentleman owes over $14,000. I don't normally show you the amount. You don't know who this person is, but it's important that you know how much he was on the hook for when you see what happened at the end of the video. So the letter to PCA, the first letter I'm going to send is what's called the letter to revoke authorization to contact the debtor. And I'm also going to send a letter asking for an assignment proof that they are assignees of the Cross River Bank debt. So attached to the video will be the actual letter that you can send or conform it to the debt situation you're in. Take a look at the TLA, Truth in Lending Disclosure Statement. That's the lender, Cross River Bank, saying they're giving it to the borrower. Look at the words best egg, and also then the part of the loan agreement, best egg, loan agreement, and promissory note. I don't do much with best egg. It's sort of a fluff throwaway. I'm focused on Cross River Bank, as I always am, depending on who they claim to be sending stuff to. But I did a little internet search, and if you see Shazam, from Best Egg's Help Center, what is Cross River Bank? Best Egg loans are secured and unsecured personal loans issued by Cross River Bank, a New Jersey chartered bank member FDIC, and I give you the web address there. Cross River Bank and Best Egg have a long-standing, by the way, I don't want to be saying something that's not true here. The part that says Cross River Bank and Best have a long-standing relationship, that wasn't in my search at the same time. This was a separate search. I just wanted you to see what the relationship is. Best Egg, a financial technology company, fintech, leverages Cross River Bank's banking license and infrastructure to originate its core loan products. I'm not going to say on video what that really means, but you can see there's a New Jersey chartered bank member, blah, blah, blah. They're using Cross River's license, if you will. So the letters that you send are an ownership letter to Cross River Bank and Best Egg saying, hey, how did Best Egg get it? How did Cross River Bank? We know one of them's a lender, Cross River Bank. And what about securitization? It's a fintech loan. So obviously it's being securitized, and you'll see in a minute. So you want to send securitization letters to these companies. I've written the letters for you, attached to the video. Now, here's the fun part. So you get a loan agreement, and maybe in your head you're going, well, I owe the debt, and I know I signed it, it's the original, maybe it isn't. Most credit card, by the way, cases, pro tip, it isn't the original agreement, and you can bear in on that to settle that case, because they'll never have it. Rarely they will. They'll seek legal substitution, but that's a whole bunch of fun you can have with them. So this is a typical analysis of any loan agreement that you can use to your advantage. It isn't as one-sided as you think. So let's look at number 15. This is a fun one. That's the agreement, in this case, consent, communications. You agree that we or any of our affiliates, agents, service providers, or assigns, remember that, and any of our assigns, affiliates, agents, blah, 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 can call you, leave a voicemail, artificial voice message. That is AI debt collector and robocaller. and send a text, an email, or other electronic message to you. So that's in every contract. I've counseled you in the past about this. See my TCPA video. Let's just put it up there. It's a great video. If they ignore your right to revoke, or they contact you and you don't owe this, you're not even part of it, it's $500 to $1,500 per call. So check that video out. But you'd send the revocation of consent to contact me letter. That's a letter. So you have granted them consent to contact you, okay? There it is. That's in just about every loan agreement, and we fluff it off and we sign because we want the money or the car or the house or whatever. That's human. But that gets used against you, especially with all the telemarketing, social media. See my social media rules video? They pound you with constant calls and texts, and it's getting worse, especially with the AI of it all. So you can put an end to all of it with my revocation of consent letter attached to the video. Now here's the fun one, 16. Assignment of your loan provision. Marlette's Funding LLC or its agents and designees. Remember I told you, remember assignees in that last provision. Acting solely for the purpose of your agent shall maintain offices, yada, 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 and will create a database, essentially. If you look down, recordation in the register is the sole means of assignment or transfer of the holders or assigns interest in your loan. The register shall be available for inspection by you and any holder, including assigns at any reasonable time from time to time on reasonable prior notice. It's a bit disjointed there, but what it means is they are telling you they're keeping a registry or register with Marlette Funding LLC, not Marlette Servicing, who's playing a prominent part of this case. And anytime you want it, you can ask, who really owns my debt? And let me see all the assignments. Wouldn't that be great if we had a database that we could do that? So what do? Send them an assignment letter to Marlette Servicing, yada, pursuant to the loan agreement provision 16. So you send that letter, and that's what the member did. And then you say, right in the letter you're gonna see on the side, it'll say this provision, pursuant to this provision, you said you keep a registry, send me all that information or let me know when I can visit. It's a ball buster, but it's in the agreement. They should do exactly what you've contracted. In this case, you're being sued for a breach of contract. So for them not to follow through is a breach of contract. And you can't be suing someone for breach of contract. Well, you can try if you are breaching same said contract, okay? So here's the thing, the reason I wanted you to remember the assignment from provision 15 regarding consent. Let's put it up there, 18. The electronic transactions. This agreement is fully subject to your consent to electronic transactions disclosures agreed to at the time of your application. You expressly agree that this agreement is a transferable record, meaning the rights that you're giving them can transfer to anybody that they sell the debt to or transfer it to or services the debt. So, and I'm gonna tell you first what that means. So this is the average case law in most states, Shazam. An assignee stands in the shoes of the assigner and acquires the same rights as the assigner possessed. So anytime something's assigned, whatever those rights, claims, defenses, rules from the assignor exactly drop into the assignee's shoes. So you're standing in the shoes of the original creditor or assignor. So all these loan provisions, agreements, have to be held against you, the debtor, by this guy standing in the shoes, but they also have to follow the rules. They can't breach the contract. So my thought is, send them a revocation of letter. Send, in this case, the debt buyer, because the debt buyer's claim to fame is that we are standing in the shoes of the original creditor. Again, let me quote the rule. An assignee stands in the shoes of the assignor and acquires the same rights as the assignor possessed. So whatever rights Cross River Bank or the creditor or Best Egg had, now PCA says, we have those same rights to do what we want to you, but also you have the same claims and defenses you had against those creditor entities. So consent revoked. Send that revoked letter. I've said it's from section 15 and 18 So 24, section 24 of the contract, we are located in the state of New Jersey. Remember we talked about New Jersey earlier? And the agreement will be entered into the state of New Jersey. So it's as though you were standing in New Jersey, in a New Jersey bank, agreeing to that this is a New Jersey transaction. The provisions of this agreement will be governed by federal laws, and to the extent the state law applies, is not preempted by federal law, the state law of New Jersey. There's your old friend, the governing law provision. So let's send them a governing law letter to Marietta and Cross River Bank, asking them, show me what that law is and why it is being applied in a state that I'm being sued in. I think this case was Georgia. How does it apply to Georgia? Why is the lawsuit filed in Georgia when you specifically say only the laws of New Jersey apply? How's that going to work? And you're doing it to the guy that's standing in the shoes of the original creditor. So boom, there's the bill of sale. It's your old friend, the forward flow account purchase agreement. Again, I'll read it. Sellers below, each seller, and you're going to love that. Collected the sellers for value received and pursuant to the forward flow agreement. Well, if anything is pursuant to something, it is actually more important than the thing it is using pursuant to, meaning the bill of sale is something, but it only operates through the prism, through the rules, through the regulations of the forward flow agreement. So you're entitled to that. So if you're having trouble settling a case, ask for that. And you'd use my forward flow purchase agreement letter. By the way, if you think it's just a letter, the pen can be very poisonous in court, because if you are communicating with somebody and you're saying in a good faith way, and maybe heading off problems that the court's gonna have to address, and you send letters and a follow-up letter and they're blowing you off or BSing, it's gonna help you one of two ways. Number one, if they don't help or BS, the court won't like that. If you just walk in and say, admit, deny, 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 and you really don't do any efforts to bolster your belief that you dispute or don't own the debt, what's the judge relying upon? Now you have letters and requests sent, certified, return receipt requested, keep a paper trail, registered by mail. Why are you keeping a paper trail? For the court. That's what a paper trail means. It started here, it ended here, Your Honor. And you can see I sent it certified, and there's Marietta signing on the 4th of July, or whenever they sign, 2025. Keep a paper trail registered by mail. You cannot be faulted for trying, for avoiding problems. Secondly, if you send a request for stuff, likely someone's going to send you something back, then the law firm gets a hold of it and sues you with what they have, and it's usually going to contradict each other. It's great. Or if they're both the same and they're both wrong, they just supported the fact that you say, that ain't me. So it is so beneficial to send these letters. I want to point out on that bill of sale, look at what's called the sellers. Now go to page 2. That's more, look at all those trusts. Who is the seller in this case? Well, we don't know, but we know who the signer is. Here's Marlette Servicing LLC as attorney in fact, signed by an Alex Rhodes, supposedly the chief operating officer. We don't know when he did it because there's no date. Why? Because that's what they do. They want to plug in this bill of sale with all those entities. So obviously all those entities don't apply in this case, but if it's a, I don't know, Auto Club Trust case, boom, add this to it. It's a Loan Asset Holdings Trust 2020 M1 case. They keep adding the same thing and there's no date. So it could have been signed when they say it was. Anyway, you do a fun thing here. If this guy wants to sign for this nonsense, then you write him a letter and say, you're involved in this now. So I'm sending you a letter to signer of the bill of sale for specifics. I mean, you signed your name for a reason, right? So you shouldn't have any problem telling the truth. And you include the bill of sale with his name highlighted. Send securitization letters to Marietta Funding and Marietta Servicing. Securitization letters to Cross River Bank and Best Egg. Forward flow agreement letters to Marietta Servicing. A bill of sale letter to Marietta Servicing asking who the debt was sold to and who in the bill of sale is the real owner, because you just sent me a list of like 50 people. It's a ball buster because they know that it's probably not anything that they say, but now you're going, well, you said it, it's part of a lawsuit, and under the rules of evidence and court procedure, you can't lie. So I'm just asking you to tell me the truth. Who owns the debt? Combined with all the other requests you made, combined with asking the registry, where they say specifically in paragraph 16, if you want to know who owns this debt, just go straight to the registry and we'll give it to you. Just ask. And then they don't. See how powerful that is? The court recognizes that. When you mirror it against their schlocky evidence, like in this case, that's a case. So the member did all this. He sent his letters when he found out he was being sued. He was never served. So he went ahead and went to, I always tell you, watch the court docket. He went to the court docket and found that he'd been sued but not served. In between that time is garbage time. So here's what he said. He did a little narrative about what he did and the happiness he has with us and himself. Shazam. That's his narrative. So he says, I wanted to thank you for your video about garbage time. Cross River Bank attempted to serve me twice on the now dismissed lawsuit, see attached, after my neighbor told me a sheriff attempted to serve me on the lawsuit. I went on my local electronic filing website for Glynn County, GA. I then went to the courthouse and got a copy of the unserved lawsuit. Remember, the time between when it's filed and when you're served is garbage time. That's when you send these great letters. Shocker, I did not receive any of the responses to the 3 separate requests for the purchase agreement, forward flow agreement, etc. that I sent them. I sent follow-ups and he's attached them for me. The whole summer went by and I heard nothing from them. Then the early Christmas present of a dismissal came without prejudice showed up. As always, I sent each of these certified mail return receipt requested. I have all those green cards and tracking number as well. Thanks again. So he did what I always tell you to do, send those letters. They clearly received the letters, and in response, I'll attach a follow-up letter that he wrote, and he's quoting in his follow-up letter, hey, I asked for this, but you didn't give that to me. Please give me what you promised at section 16. And that's what you do, you bust some chops. So I hope this helps. So the purpose of this video is to provide you with a ton of letters to send to work during garbage time, showing you a case study of a member that actually did everything I said, and it worked. He got it. Hey, I'll show you the dismissal. Shazam. So that is the dismissal with prejudice. I'm gonna tell you, 30 years of doing this, in these type of cases, a dismissal with prejudice, you never see them again. And that's $14,000 they went away from. They could have served him, done whatever they needed to do in the summer, as he said. They sent in a dismissal. There's a 0.01 chance that he sees that case again. I think those letters put them off. And that's usually what happens, because essentially the letters are saying, put up or shut up. And they decided to shut up. But don't you shut up. I want to hear your voice loud and clear with all these letters. Let's put them up there attached to the video. And all those letters can be received from Killdebt.com, or go to Parker GPT. I'll embed those letters in and just ask for them in the prompt, and Parker GPT will give you the letters with all the information, all your address. It's going to do it all for you. We do it all for you. Thank you. Like, love, and subscribe and share. Bye-bye now.